Hello everyone, this is Rajiv S. Khanna for Immigration.com, Law Offices of Rajiv S. Khanna PC. Uh, Last few days, a question has come up repeatedly, and I thought I would talk about it so everybody has a better idea. What do we do when our visa gets denied under Section 214B of Immigration and Nationality Act, which basically means the consulate doesn't believe you're going to come back, so they deny the visa, saying that you have an immigrant intent, which you have not been able to rebut. So the idea is whenever somebody goes for a visa stamping, they actually are presumed to have immigrant intent unless they prove otherwise. Out of all the visas, A, B, C, D, E, F, G, H, all the way to V, um, some visas are immune to this problem. What are the visas that are immune? H, H1 as well as H4, L1 as well as L2, O1, derivative O1. These are visas that are immune to by law almost. HL clearly by law, O by implication. These visas, if you have a green card going, the consulate is not going to deny your visa for that reason. On the other hand, notorious visas that are very susceptible to this problem, B visas, B1, B2. I'm trying to remember all the F visa, F1 as well as F2, which is students. J visas, J1 as well as J2. A lot of physicians will tell you they've had a visa denial on 214B. The biggest problem with 214B is it is extremely difficult to fight it. I have taken a case day before yesterday, in which an F visa was denied on 214B, and I think we have a fighting chance. Why? Because the visa applicant has come to the US many, many times, and she has left within her time permitted. So she's been a frequent traveler on a B visa. Her F visa denial is extremely unjustified, in my opinion. So, what do you do when 214B type of denial happens on these visas? By the way, I want to point out even TN holders, strictly, they are not going for visa stamping, but TN holders can be stopped at the border if their green card has been filed. So bear in mind when TN holders apply for a green card, they should be careful about this particular factor. Before I get on to what you should do if you get denied, let me just very quickly go through the visa alphabets. A visa, diplomats, no problem. They don't have this issue of, as far as I remember, of green card having been pending or any kind of immigrant intent. B visa, you have a problem. C, D, E visa also usually is not a problem, especially E3 for Australians, where E3 is kind of an equivalent of H1. Uh, the only thing you have to establish for E3 is that you do have an intention to come back, but not to the same degree. Let me rephrase that you have a home in Australia. It does not, the degree of proof is not very high. So it's very easy to meet that degree of proof. I don't remember the exact phrase used in the law, but E visa people are okay. G visa are okay, no problem with 214B. H I said is okay. I, which is international journalists, um, media representatives, may or may not. J, definitely a problem. K1, K3, they are obviously no problem at all because they are fiance and um, spouse of a US citizen visas. They are obviously meant to go into green cards. So you're not going to have any problem with 214B on K1, K3. L, I already told you, no problem. M, which is folks who are doing vocational training, they can have this problem. By the way, H2B visa can have a major problem with immigrant intent. These are people who are coming to USA to perform some skilled labor. Okay, so L, M, N, O visa, I already said, no problem. P can have a problem, performers, athletes, etc., but usually not. Q, exchange visitors can have a problem, or usually not. STU, not quite a problem because they're done within USA, and they usually are either victims of crimes or people who are assisting in criminal investigations. I think I got it all right. I Instead of doing 10 hours of research, I wanted to share with you whatever I know, because this issue has come up so many times in relation to tourist visa. In the last few days, it almost begs for it to be put down into a conversation. So if you have any very, very specific questions, of course, I'll be happy to try to answer them if you post them to our website or in the forums. I will try to answer as many as I can, or join me in the next community conference call. We can talk about it. Um, so what do you do if you get a 214 denial? 214B denial, normally there isn't much we can do. But if you've been to USA before, or if there's something unique in your case, we can ask the consulate to reconsider. And if they are unwilling to, unable to, we can ask the visa office in Washington, D.C. to intervene. You can also contact if you have family in USA, or if you have your employer in USA, you can ask them to contact the congressman, local congressman, and seek their intervention. Typically, that's not very helpful, but you can try. If anybody from the bar feels a lawyer tells you that, oh, I can fix it, be mindful they may not be able to. Okay. Especially when you talk with lawyers in your own country, that makes me very nervous, because we've had some cases where local lawyers in other countries did some strange stuff. They had some hookups with the consulates and ultimately got caught. See, the biggest problem is, in fact, I'm going to do a video on that if I can tomorrow. There is a problem with fraud or misrepresentation. If you make a misrepresentation in attempting to get any immigration benefit, you can be barred from entering USA forever. Okay. So going back to 214B denials, you can ask the consulate to reconsider. People reapply. If you have a case that begs some special consideration, like I gave you an example of, that somebody who'd been to USA many, many times, that's a classical case. One of my friends asked me the other day, they wanted to know, if their girlfriend is refused a B visa, is it okay to bring the lady in on a K visa, a K1 fiance visa? And my take on that was, I said, listen, do not use fiance visa in lieu of a B1 visa or B2 visa. Because if you don't have the intention to get married, the government can consider it to be fraud. So just back off of that. Make sure that that's what you want to do, which is marriage. Within 90 days, you've got to get married after they enter USA. So that said, I think I've covered pretty much everything. All that I want to talk about 214B. Oh yeah, one more point. There is a legal fiction created in U.S. laws, immigration laws, about ties to your home country. So they say you can overcome 214B denial if you have ties to your home country. That's, in my mind, that's a legal fiction. To demonstrate ties is very, very difficult. Yes, of course, if you have all your family lives in your home country, that's a good example of ties. But to say that I have property can be sold. I don't think that's really ties. I have business can be managed by other people, businesses can be sold. So it really, demonstrating ties to your home country is usually a difficult thing to do. Okay? Well, good luck, and if you folks have any questions, we are always here.